Hey, you guys, I hope everybody's doing super well. There has been a lot of motion going on with Fani Willis and some updates in the case that other creators have been leading the charge on covering. But one thing I really want to talk about that I haven't seen getting much buzz is this lawsuit coming from a group called Barred Business. And it's worth noting here that it is Barred Business that's bringing forward this complaint. They are the petitioner, but the attorneys submitting this complaint, writing this complaint, are Julian Clark, Brandon Buskey, who are applying for their pro hoc vice status. It's still under application. And then Andreas Lopez Delgado. These are all ACLU attorneys that are writing this complaint for their client, the petitioner here, Barred Business. They are using some information from an ACLU report to file a lawsuit against Fani Willis, alleging that she's not living up to her promise and her duty as a prosecutor in making sure that incarcerated persons are getting their fair share at not just a trial, but an indictment. So, in other words, people are being held in jail indefinitely, not just for days or a couple of weeks, but we're going to see some examples of over more than 400 days where someone is sitting in jail without an indictment. Now, if you've stuck around and you've heard some commentary, not just from myself, but from other streamers, one of the things that Fani Willis's district attorney's office came in with a mission statement for was, hey, we've got this backlog of cases in Fulton County. There's been a backlog because of the prior administration was one reason they gave, and because of COVID creating, kind of throwing a wrench in productivity. That was the second reason they gave. They said, hey, elect me. I'm going to get into this office. I'm going to clean up that backlog. So if we go over to Fani for DA, you can see that these campaign pictures are, during COVID era, everyone's wearing the masks. Meet Fani Willis. We're going to see what's bolded here by them. This isn't me highlighting it. In just her first term, Fani has fought to make Fulton County safer for everyone who lives, works, and visits here. She has taken on gang violence, which wreaks havoc in our communities by bringing major indictments against gang leaders. She and her team have forged new relationships with local, state, and federal law enforcement agencies to keep Fulton families safe and bring justice to victims. Fani has created a new and transparent process to keep the public and the police department informed of her work so they can best coordinate. She is now providing, and this is bolded by the website, she is now providing timely answers to families, the community, and police officers about how cases are being handled. She is committed to making fact-based decisions about the law while holding officers accountable where warranted. Now, what we're about to read is super important here. And before I go any further, I want to say two things. With everything going on, the spotlight is on Fani Willis, and that gives us a unique insight into other things that are going on there. People are looking under the rug and uncovering what the Fulton County District Attorney's Office is doing. We've even gotten some buzz about, Nathan Wade and how he was hired for $550 an hour to investigate prison deaths over in Cobb County. That's something that we probably wouldn't have had such a huge spotlight around if all this stuff with the disqualification hearing wasn't happening. So keep that in mind, that there's extra attention on what's going on in the Fulton County DA's office for a reason, but this could be the same type of thing that's happening in other areas. The second thing I want to highlight is we're going to be talking about a diversion program, which again is not unique to Fulton County. Other areas have this type of program as well. The intent of a diversion program is to get rid of some of that backlog, keep holding counts down. That saves taxpayer dollars, right? But it's also meant to be a benefit for the community. So if someone's a first-time offender and it's like a petty crime, why spend the time keeping them in a holding cell when we can divert them, don't even need to clog up the court calendar to deal with it, right? So there's a twofold benefit there. And it's something that when you're discussing budgeting, if you have a program like this, you're going to allocate resources for, you're going to allocate labor for, and the expectation would be if you're allocating a budget for something and people's time towards, labor time towards it, we should see effects of it. So just keep that in mind, that when there's a program like this, it's something that you ask for a budget for and allocate employee resources towards. Let's see on Fani for DA what she says about this diversion program. Fani understands that prosecution is only one part of the strategy when it comes to protecting Fulton County. Her office has partnered with police, other government agencies, schools, religious leaders, and community organizations to build programs that will help those most at risk to being caught up in the criminal justice system. She's created Fulton County's first ever, pre-indictment diversion program. So we want to divert people before indictment, keep them out of being caught up in the criminal justice system. So this pre-indictment diversion program, which gives offenders who would benefit from a second chance the opportunity to earn one. She's partnering with community organizations to give those offenders, especially young people, the opportunity to gain life skills and the responsibility that comes from community service to have a better path forward than one marred by a criminal record. So, on one hand, I heard about Barred Business bringing this lawsuit forward. This is what we're going to really take a look at here. But when you partner it with this background context about how Fani, one of her campaigns, one of her promises is, hey, keep me in office because we have this diversion program. It's great. It's going to do all these things. But now a very progressive organization that advocates for the incarcerated is bringing this lawsuit forward with the help, with the data from an ACLU report. We're going to look at some of the key findings of this report. But when you tie it all together, and I saw AV talk about this video where Fani's talking about these same promises we just read a little bit on the website, something clicked in me and I was like, this is a key promise. This is a key tenet of her, why I'm here and why you should keep me here. And yeah, now she's getting sued by a very progressive organization with data from the ACLU, chipping away at her because people are sitting still without indictment in jail for more than 400 days. I'm going to link to AB to the Seventh Power's full stream. She has covered so many of the new happenings from interviews and messaging that's going out there from the district attorney's office, as well as the attorneys for the co-defendants in the Trump RICO case. Really, really, really great stream. So this video is going to be timestamp linked to this exact moment, but explore around, start it from the beginning, check out some of the other coverage that AB has done. When I saw this coverage from, basically the Georgia PBS syndicate, Georgia Public Broadcasting, all I could think of was the stream I had just seen from AV and how she played this clip with Fani Willis, because this is what Fani Willis says.
That's it. This is when Fani launched this website in 2022. Welcome to our website. As we start our second year in office, I want to update you on our progress and let you know about our ongoing efforts to make every part of Fulton County as safe as it can be. When we took office, we found a backlog of cases unprecedented in Fulton County's history. Because of the cases that were stalled by the pandemic of our courts and the prior mismanagement of this office by the former.
So she's giving those two reasons: COVID, backlog, and prior mismanagement of the former administration, which, if you guys live in Fulton County, I'm not doubting that at all. But you're coming in, one of your keep me in office promises is, I'm going to clean up that backlog. That's why it's important.
Administration. We found 22,000 pending cases, half of which hadn't even yet been indicted. We also found in excess of 50,000 closed cases that were not properly entered into the public record. I have brought in new, highly experienced staff to serve our community. And
so that's what I'm saying. She's bringing new staff in. That means resources are being allocated to this program. There's a budget for it. There's a plan for it.
We have been working around the clock to clear the backlog and make sure we get dangerous defendants indicted and keep them off our streets. We are pushing cases through to trial or pleas to get justice for victims, and we have made real progress, but we still have more to do. In 2022, we are going to be continuing those.
Notice the reading.
So, by the way, the ACLU report was 2023. So I think she's recording this in 2021, saying what she wants to do in 2022. We have the ACLU publish a report that we'll look at some of the fast facts, but I'll link the full report in the description. It is 23 pages, and I don't want to make this too long, but it will be in the description for you there, as well as AV's video. But again, this is something that they published in 2023. And here's Fani speaking about what 2022 is supposed to look like.
Those efforts, and we are going to be working on programs for restorative justice and alternatives for Fulton County. Those programs are going to make Fulton County a safer and more just place. We have created a records restriction program that has helped hundreds of people to get jobs and apartments by assisting them with the process of removing old incidents from their record. We have invigorated our conviction integrity unit, and we are actively considering and taking action to overturn unjust sentences and convictions. And we have created, for the first time in Fulton County's history, a pre-indictment diversion program. We have done this.
Pre-indictment diversion. We just read a little bit about that.
There's a pre-indictment diversion program. 17 defendants in the Trump RICO case. Put a 1 in the chat if you think that they were given an opportunity to have a pre-indictment diversion. Put one in the chat if you think they were offered that. Put a 2 in the chat if you're like, no, AV, like they just got indicted. They just got slapped with indictments. Like you'll get an indictment. You'll get an indictment. Everybody gets indictment. Everybody gets a RICO.
Stop
Everybody,
it,
all
AV.
of it, everybody.
AV and her props and her post-its.
It's just a question. Let's keep going.
Yes, so we can connect people who need help with addiction and mental health challenges with the assistance they need without marking them with the scarlet letter of a felony indictment. This year, we are even
Oh.
more committed to improving and expanding those programs. We thank all of you, especially our community partners, for your support in making Fulton County a safer place. We look forward to working with you in 2022 as we move Fulton County forward.
So again, I'm going to link to AV, this specific stream from AV, but you can use it to get to her channel and check out some of the other streams that she's done on some of the happenings in with the disqualification and the Trump RICO case. Really, really great stuff from AV, very thorough research and very entertaining. Like she's very talented in the way that she puts her videos together. So links for that in the description there. But the importance of that is, again, it's something that I tied into, we're looking at this promise. We heard some of the same sentiments echoed in the video that we just watched through AV. But yeah, when I had her video in the back of my mind, and now like reading the same sentiments on her Fani for DA website, and then I see this comes across my radar. So this was published on March 21st. I don't really remember when exactly I read it, but I know I was already aware of the video that AV covered on her stream. You see this Fulton DA Fani Willis sued over incarcerated people waiting in jail without indictments, and this is 2024 now. So what we just watched was her promises for 2022. She says, I'm bringing in manpower and resources, and we're going to get rid of this backlog. We're going to do all this pre-indictment diversion. But now she's being sued because incarcerated people are waiting in jail without indictments. And this suit is coming from Barred Business Foundation. And the who's who is important here because this isn't just some Trump affiliate, some conservative party launching fire over at Fani Willis. This is coming from a progressive organization. And they're using a report that was put together by the ACLU. And I think it's an incredibly important issue, and even though I'm sure, again, this is not limited to Fulton County, this is where we're getting spotlight on, and we have the opportunity to kind of look behind the curtain and see a little bit more how it works. But I think these are important issues that we should be aware of because they affect taxpayer dollars, and they really impact individuals. Imagine if you were spending 430-something days in holding without even being charged with anything. You're not indicted. Just imagine how that would impact your life. You'd probably lose your job because you couldn't show up to work for a full year. You have a stigma. Anyone that knows you is going to notice that you haven't been around. Even if they don't know that you've been arrested and you're sitting in a cell somewhere, they'll notice you're suddenly gone. If you're a parent and you have kids, you're gone from your kid for over a year. It's a huge injustice, and it's one that costs taxpayer dollars. I mean, it's not free to house someone. So if you're spending $100, $200, $300 a day to keep a roof over someone's head while they're incarcerated and they're not even charged with anything and they're there for 400 days, that's thousands and thousands of dollars just to house this one person. And imagine that at scale. So I'm going to get off my soapbox, but it's something that really bothers me. I don't want to conflate the issue with, if a repeat offender of violent crimes that have victims, is getting out on, bail reform issues. I think that's a separate issue. Here we're talking about pre-indictment diversion for people that deserve a second chance, according to the mission statement from Fani Willis. These are people that don't have a prior record that are coming in, and they should be going through this pre-diversion program that there's money and resources and manpower being dedicated to, but we're still going to end up with people sitting behind bars, first-time offenders, without charges, sitting behind bars. So I'm off my soapbox. We're going to see what GPB has to say. And again, this is going to be linked in the description if you want to check out the full article or listen to it. The Atlanta nonprofit Barred Business Foundation is suing Fulton County DA Fani Willis for allegedly failing to inform a judge when someone is held in jail on felony charges without being indicted for longer than 45 days. And they give a quick summary of the report that we'll look at some of the bullet points from, but they're saying that the ACLU found that, at one point, more than a third of people at Fulton County Jail fit this description of being held on felony charges without being indicted for longer than 45 days. So, a third of the population, according to this report, they were supposed to have informed the judge hey, this person's been sitting here for more than 45 days and there's still no indictment. Over a third of the population that was in holding was there for more than 45 days without this actually occurring. So here, Peter Biello, the first question we have here is, when you asked Fulton County why these people were waiting so long, what did they say? And Julian Clark, who is the ACLU attorney, so we specifically sent in records requests. So there's a trail of this. This is going through public records requests for information. But we never asked directly any officials in the county why people are being held. So they don't have statements from particular persons, but they have documentation on the record of this process to request this information. What did they say in response to the information requests? So we specifically requested whether they were complying with a court rule, which is subject to the lawsuit. And they responded that they have no information that is relevant to our request. This is huge. This is why I decided I had to do this video. Which suggests to us that they are not in compliance with that rule. Now, this goes back to when, if I'm going to the grocery store and I forget to make my grocery list and I'm supposed to, hey, you ask me, can you pick up bread, eggs, and milk? And I can go and I can keep those 3 things in my head. And if I forget, oops, that's on me, right? I'm not required by any statute or code to write a written list that I'm supposed to respond to and produce bread, eggs, and milk. But as a public official, as a public office, there's procedures. There's standard operating procedures. There's processes that you need to follow. There's records that you're supposed to keep. There's no discretion with some of these records. It's a shall, not may type of scenario. But here we see Julian Clark saying, hey, we filed these public information requests, and they respond to us that they have no information relevant to our request, which suggests to us, and Julian notes in here, which suggests to us that they are not in compliance with that rule. Because if they were doing it, there would be a record of it. And Peter Biello, otherwise they'd have something to show you. Exactly. Okay, so why is it important for a judge to know when an individual is kept in jail for that amount of time without an indictment? And this is going to get into the standard operating procedure, the process that's meant to be followed. The reason why it's essential to know is that Fulton County Jail now, and for a long time, has been experiencing overcrowding. That's bad conditions, that's a civil rights issue, which is why I'm sure the ACLU is doing their report. But again, it's something that taxpayers and voters would care about. You're asking us to vote you in. You're saying one of your mission statements, this is part of your platform. And you have a program that some money is going to. So even if I don't care about the impact to the individual, as a voter, is there a mismatch? Is it happening? Is there a disconnect? So there's terrible conditions in the jail. People have died. Dozens of people have died over the last couple of years. And right now, given those conditions, if there's anyone that's in the jail that hasn't been convicted, or the judge has an opportunity to expedite their case process, it's essential that the judge be aware of it. Is this unique to Fulton County? So Julian says that our investigations focus on Fulton County, but our understanding is that this is likely something that's happening all over the state. So again, this is important we're looking at microscopically through one county because there's so much, there's data, there's research, there's work, there's people making public records requests. There's something for us to actually look at. Someone's prepped the what is it called? The little slide when you put something under a microscope. Someone's prepped the slides for us. It's there for us to look at. But Julian and Peter Biello importantly note that this likely isn't just happening in Fulton County. Here they keep the scope limited to the state, and we know that Cobb County had an investigation into prison deaths because of overcrowding and conditions. That's where we get that famous quote from Nathan Wade saying he didn't have work product or documents about his report that he was getting paid $550 an hour for, that he just had what's in his head. That's where we get that interview from. And hold up, I said I was going to just include the link to this interview, and I'll still do it. It'll still be in the description. But let's look at this. This is what I'm talking about. You're supposed to have written records of what you're doing. You're being paid $550 an hour to investigate Cobb County prisons. What does Nathan Wade say about the records and his work product? And it looks like he's reading from the screen here too, so.
Stands today, you have no work product whatsoever associated with that undertaking, correct?
Oh, I have work product. It's just not in the form of documents, communications, or record memorializing, reflecting evidence, or relating to the work as you've put it here.
Okay, well, what work product do you have?
Well, I have obviously my brainchild, what's going on in my mind about it. That's what I have.
You heard that right. The work he's produced over the past 123 days, all in his brain. And when he did use paper to document his findings, he threw it away.
Got done with it, destroyed it, and walked out.
Okay, so when you did take notes, you destroyed them when you were finished with the interview?
Yes, they're in the sheriff's department.
2 of those inmate deaths include...
So I don't know, you guys, but let me get back to the rest of the video I recorded. So Julian Clark aptly notes that this likely isn't an issue constrained to Fulton County. So Peter Biello says, hey, we have limited resources. So what can the system actually do to, even if the judges were told that these people have been sitting without an indictment, then what? So Julian Clark says, the chief judge, as the head court administrator, has the authority to bring in other judges, whether retired or judges who are just in other jurisdictions, to help expedite the court's docket. So that's one of the things that we would hope the court does with this information, is that they use their discretionary funds and whatever resources they have available to help them expedite these cases. Peter says, the Fulton County Jail is an overcrowded, dangerous place, as you mentioned at the outset. There have been several deaths in a short amount of time at the Fulton County Jail. Do you think compliance with this law would help the jail's overcrowding? And if so, how? And again, this is really where the ACLU comes in because, civil liberties, you're being denied your freedom if you're incarcerated without an indictment, right? But to the point where you're also dying. This is the exact type of thing that the ACLU, whatever local branch, will step in and try to investigate. And this investigation is important, right? Because if we don't have this research, it's harder to make a case and bring a grievance forth. That information needs to be there, right? The research has to be done for it to be more than a, hey, I think something's wrong here. The research is a huge catalyst for change, for advocacy. So it's really important that the ACLU came in and did this research with Fulton County. It's much different with Cobb County where we only got, this is what's in my head. Yes, absolutely. Another thing that could be done is that the judges in Fulton County could start evaluating people's ability to pay. So if they're being charged with a misdemeanor or even some felonies, judges are required to evaluate whether someone can make a certain bail determination. And right now, that's not happening. So our hope is that compliance with this rule will bring greater awareness and hopefully spark some change. So there's an issue, right, against distinguishing this from bail reform policies. This issue is before a bail determination would even be made, right, or offered. And they do note here that Georgia Public Broadcasting did reach out to Fani Willis, but did not receive a response. Now I want to hop over and we'll take a look at this complaint. But before we get over there, let's look at some bullet points from this ACLU report, which specifically, why are they doing this report? Hey, we know that building a new jail isn't going to remedy the problems of jail overcrowding. Some of these jails are intolerably overcrowded. Some of these individuals are sleeping on the floor. There's insufficient personnel, inadequate plumbing, heating, ventilation, and medical facilities. This is something that's stemming from the 1980s. A problem where people would be there for months. 4 months, this is back in the 80s, without seeing a judge, so no indictment. And then this next sentence here tells us why this matters. Because of this, they've been sitting there for 4 months already, without indictment. When finally that day comes around, many individuals would plead guilty to anything if it would allow them to go home. So this is a problem that's been stemming from the 1980s that we heard from, 2021 websites and a 2022 platform. We want to ameliorate this problem. We want to create these programs to help get rid of some of this. But if you hop over to the YSL trial, which is one of the main 4 RICO cases that Fani's district attorney's office has brought forward, instead of really dealing with this backlog, we have YSL Slug, and I did a video on it. I'll link to that in the description. He was given a plea deal that says, hey, you can't testify truthfully about anything that we're charging any of the co-defendants in this case with, but if you sign this, we'll let you go home. And it was after they had denied him a hearing for bond or bail multiple times. Multiple attorneys had made a request to the court for a judge to speak to this man, make a decision on this man's bail or bond. He was stuck there for 7 months, allegedly for a crime that had already been dealt with. He was stuck there without a hearing. And so finally, they put this plea deal in front of him when they need something to lock in my opinion, they need something to lock down in this YSL RICO indictment. They give him this plea deal with very, very interesting language about how he cannot testify truthfully if he agrees to sign this plea deal. And here they're highlighting, many individuals would plead guilty to anything if it would allow them to go home. So this isn't just a problem of impact to the individual in question. This is also a civil rights issue for the person if whatever you're pleading to, whatever the terms of your plea deal involve, could be a violation of someone else's right to a fair trial. One plea deal can be a civil rights issue for more than the person signing the plea deal. So the ACLU goes on to say, hey, last year the prisons, they came up with more leasing. They wanted to deal with the overcrowding by, making more space available to hold these people to deal with the overcrowding issue. But that didn't eliminate the overcrowding or meaningfully improve the conditions of Fulton County's detainees. Even though they were authorized up to 700 beds at the Atlanta City Detention Center, the sheriff has struggled to fill half those beds as individuals remained on the floor at Rice Street. So they're being held in one place. So these beds that we're spending money to lease aren't even being filled because they're still being held at a certain stage without an indictment. So the ACO says last year, before we did this report, a year ago, we advised Fulton County leaders that overcrowding in Fulton County could be solved by simply complying with state law regarding setting bond amounts, indicting cases timely, not detaining individuals for misdemeanors, and diverting eligible detainees from custody and into programs. Since our recommendations, 13 individuals tragically died in custody, and some stakeholders began to make meaningful steps more in line with our recommendation, resulting in the detained population decreasing by more than 500 people. So we've made some progress, but 13 people still died in custody because of these conditions. So while strides have been made towards alleviating overcrowding, there's still more work to be done. And what's important is they bring in national statistics here. So people are simply spending too much time in custody in Fulton County specifically. Nationwide, people only spend an average of 30 days in custody in local jails. But in Fulton County, however, the average person can expect to spend 291 days in custody. As such, we believe there is still much work to be done for the following reasons. So the first issue is the cost of bond, the price that's set for bond. So even though they believe that Fulton County is working to address this, they're still not meeting what's the procedure for it, which should be much earlier in the process. Georgia law requires the court to consider an individual's ability to pay when setting bond within 72 hours. The second reason they give is that there's still too many cases who have not been indicted within 90 days. We just heard the average was 291, even though nationally the average is under 30 days. Last year they identified 750, and this year they identified 503. But the legislation says that no person should be in custody longer than 90 days without having their case indicted. Now let's hop over to the findings of this report where they focus in on this over 90 days complaint. Well, the number of individuals in custody trending is trending in the right direction because it's reduced a little bit. People are simply being held too long. They bring up these national stats of, under 30 days nationwide, and how the Georgia State Senate has said, hey, this should be our target here for Fulton County too. But instead, the average is currently 291 days. That's 9.5 months. That's like enough time to have a baby. That's almost a tenfold increase from what this goal should be. And here they represent it. They put the data into this chart. There's a weird little blurb at the bottom of this chart that says, it's in gray here, really faint. It says several people who stayed in confinement for over 2,000 days removed from charts. So they're not including these extreme outliers in this data and maybe not in that average. But here we're also going to get, also of note, are the demographics of who is in custody in Fulton County. In Fulton County, 44% of the population's white, 45% of the population's black. In Atlanta, 48% of the population's black, 41% of the population is white. However, 89.6% of those in custody in Fulton County are black, and only 9.3% are white. Black people spend nearly 2 months on average longer in custody than white people. Here you can see the averages here. So look at the difference there. I mean, honestly, look at the difference all the way down, but perhaps you could argue that this is a pretty small sample size. It's only 11 people, but this is a fairly large sample size. And we have a almost 60-day difference in the incarceration length, so 2-month difference. And here they offer some analysis saying, hey, part of the issue is that people that can't afford their bond amount and the bond amount isn't being set correctly, they're stuck in there. So wealth-based detention is one problem that the Fulton County DA could use to solve this overcrowding problem for people that are detained without indictment or without bond or bail, without a reasonable bond or bail. And this data, this chart, I think is really important because you can see how it's front loaded, and it's kind of because they scale this. So all of this data is for amounts of $100,000 or less. And I'm personally not clear on where this x-axis and where the 100,000 starts. But it looks like if we were to say it starts in the center here, there's more than 10 brackets here. So I would assume that anything before, these first two bars would be, perhaps, this is just a guess because the x-axis is not the best chart to represent this. But for all we know, these could be a couple $100 here. A second here, they go into, hey, the delay in issuing indictments. So this is really that pre-indictment diversion program, that there's a whole program to getting the funding and the budget and the manpower allocated for. Fulton County's delay in issuing indictments remains a major contributor to its overall jail population. After an individual is arrested in Georgia, prosecutors must formally charge the person for their case to move forward. For felony cases, this is generally done by prosecutors seeking an indictment, a formal charging document that is returned by a grand jury. Under Georgia law, a criminal defendant who is arrested for a crime and denied bond must have their case presented to a grand jury within 90 days. Otherwise, the defendant must be granted bond. And this is a statute. This is the way it's written. This is how it's supposed to be done. This isn't just, hey, we think it should work this way. It's already written into the legislation. So, no bond. If you're being held for more than 90 days, then you need to be offered bond. And the reason for this statute is to protect against indefinite detention without grand jury review for these indictments. But yet, hundreds of people in custody in Fulton County are forced to wait much longer than 90 days before their cases are indicted, sometimes waiting years. So this year, part of this report, they found that 1,114 individuals, or 30% of the total incarcerated population, are detained while unindicted. 45.2%, so 503 of these individuals, were in custody for 90 days or more. 207 of those 503 were in jail for over 6 months. 22 people have been in jail for over a year, and 3 have been in custody for over 2 years. The average length of custody for this report was 106 days waiting for an indictment. So in point C in their analysis here in this report, they say that, Fulton County has done a great job. Most of the improvement that we've seen is because of the reduction of population of those charged with misdemeanors. So they met with the Solicitor General, Keith Gamage, who's responsible for misdemeanor cases, to hear what has worked to reduce the population of those charged with misdemeanors. And Gamage cites that the implementation of the state expedited accusation calendar system requires his office to work around the clock to ensure that prosecutors have the initial incident report and that the victim's contacted right away, and all the formal charges, plea offers, and discovery may be sent the first day following an arrest. People in custody have an opportunity to plea less than a week after their arrest and have a jury trial within 30 days. So this is that's clearing out this magistrate bottleneck for misdemeanors. So Solicitor Gamage is saying that, hey, we still have some room for improvement here, but we have taken down this process, which could have taken up to 10 months, to sometimes down to just 1 day for arraignment for misdemeanors. But here's where we get to diversion programs. This is the ACLU talking about diversion programs. Pre-arrest diversion continues to be underutilized at a rate similar to last year. So no changes. All this so far, we've seen, hey, there's been a little bit of reduction. Or here with Solicitor General Keith Gamage with misdemeanors, we've seen a dramatic reduction. But over here in diversion land, we're not seeing that. So all of these programs, Policing Alternatives and Diversion Initiative, PAD, these things that we saw not just in this one paragraph here, but also heard about in the video that we watched through AV's channel. These programs have not been used to their full potential, nor have they been scaled to adequately serve the greater Atlanta population. Diversion programs have the potential to significantly impact jail overcrowding because in lieu of the normal criminal legal system cycle, which is booking, detention, prosecution, conviction, incarceration, people are instead referred into a trauma-informed intensive case management program where they can receive a wide range of support services, such as transitional or permanent housing, drug treatment, and mental health care. Yet, in order for these programs to meaningfully reduce the number of people arrested and subsequently jailed, law enforcement officers in the greater Atlanta area must exercise discretionary authority at point of contact to consistently divert individuals to a community-based harm reduction intervention for the over 150 diversion-eligible criminal offenses. So there's 150 offenses from the codes, the Georgia code. There's 150 offenses that could be eligible for this diversion program. And only one Atlanta Police Department, Georgia Tech Police, and MARTA Police can use PAD, even though there's many more agencies among the 15 cities in Fulton County that feed into this main Rice Street detention center. So 3.4% of the total jail population, all of them, that whole 3,000 individuals that are detained, 120 people total were in custody for divertible charges. And this year we're still at 3.2% of the jail population. And here I think this section's worth noting because pre-arrest diversions are, before there'd be an opportunity, hey, we have this person detained, they're incarcerated, they're sitting here waiting for an indictment, and then they end up being there for more than 90 days. Pre-arrest diversion could reduce that number before it even get to that point. So they do say that there's some work that could be done here on the policing side. And really what we're going to see with this lawsuit being brought forward by Barred Business Foundation is going to be a focus on things that happen after the arrest that are Fani Willis's wheelhouse. But to close out this ACLU report, I do want to go over the narratives of impacted persons. This really gives you something tangible to think about, how this actually impacts a person, not just taxpayer dollars and someone sitting there and we're paying to keep a roof over their head, albeit an inadequate and insufficient roof. So they say we wanted to share some experiences. We spoke with many justice-impacted individuals who offer the following. I experienced deplorable conditions that myself, along with many others, have experienced at Fulton County Jail. My intention is not to complain about it, but to shed light on the subpar living conditions that inmates are made to go through on a daily basis. The overcrowding has already made unsanitary living conditions worse, and the jail has created an environment that is not only detrimental to physical health, but also takes a toll on everyone's mental health there. Now that's a problem because if your mental health is getting worse while you're incarcerated, and you haven't even been indicted, and there's a potential that you could be eligible for this diversion program that Fani Willis is working on, but your mental health is getting worse while you're sitting here waiting with no answer, no indictment. What are your odds when you get out if the problem was your mental health in the first place? And this is only exacerbating it for 90 days, maybe up to a year or 2 years. Someone says that the overcrowding amps up tensions between people that are incarcerated together. That can lead to conflicts and fighting. So now you're being held, you're not indicted with anything, but now you're somehow in a fight where you're being detained, which is now an issue of itself because your behavior while incarcerated impacts decisions like bond, bail, even sentencing post-conviction. So this person also notes that a lot of the people I knew didn't even do anything violent, but they threw everyone together in the same conditions. It was terrible. So people that are in there for something that could be eligible for a diversion program because of the type of, crime, because of the type of charge that it would be. They're thrown into a holding cell or in the same space at this detention center with someone that is charged with something violent, and now they're in a situation where a fight breaks out, there's conflict, and now they could be associated with a violent act while incarcerated, even though they shouldn't be in there for more than 90 days to begin with. And if we achieve the national average, 30 days, that's a much smaller window for this type of conflict to occur, right? But it all layers on top of itself. And here this third person says, hey, the guards are abusive, not just verbally, but they also make jokes about shutting us up with their fists. And they made good on these threats when someone was handcuffed and dragged into a private room. And here, the ACLU gives their recommendations, and hey, we need to get this 291-day incarceration average without indictment down to the national average of 30 days. And one of these recommendations is ensure the district attorney continues their efforts to identify and release any individual who's being held on bonds that they cannot afford and end wealth-based detention. So fix that bond issue. Also, ensure that the district attorney review any cases of individuals in custody for over 90 days without indictment to ensure that the bond is set and that an amount is set that is affordable. The district attorney should be notifying the Fulton County chief judge of individuals who have not been indicted after 45 days under Georgia law. Ensure that the district attorney continues to reduce the time to indict cases so that no one has to wait longer than 90 days in custody before their case is presented to the grand jury. So these recommendations are all things that relate directly to Fani Willis and are greatly contributing to this holding time for detainees that have not even been indicted, even though code requires that the judge is notified. after 45 days if someone's still being held without an indictment. And it's something that this platform was supposed to be reducing. And the ACLU report says on this specific regard, there really wasn't a significant change over the last year. And we're going to re-recommend these things that we recommended last year. And those things are precisely what Barred Business Foundation is bringing this lawsuit forward under. Right? And here's why. So they're going to say this is a petition for a writ of mandamus filed on behalf of Barred Business Foundation, the petitioner, to compel Fulton County District Attorney Fani T. Willis, respondent, to comply with her mandatory public duties under OCGA and Uniform Superior Court Rule 26.3. Now, this is what we've been talking about already. The district attorney shall. They're italicizing that because that means no discretion. It's not a power that we can use if we want to. It's a must. The district attorney shall notify the chief judge in writing of the name of any unindicted accused who has been in custody under criminal felony charges for 45 days within 2 business days after said 45-day period has run. Must be in writing. This is a quote from the code. Must notify in writing within 2 business days after this 45-day period has run. But we know how many have been in there for not just over 45 days, but over 90 days. 90 days is well outside the window of a 2-day business window of 45 days. They emphasize that Georgia code also says that these rules are binding and must be observed. So it's a must, it's a shall, there's no discretion. The petitioner here, Barred Business, they go on to say that respondent, it's their duty, it's Fani Willis's duty completely. And when we, through counsel, requested any and all records showing Fani Willis's compliance with all of this, Fani's office responded, "We do not have responsive documents." And we're going to go down and look at this Exhibit B, because it's really the crux of this interview here with Peter Biello and Julian Clark. Hey, what does that suggest? Oh, that suggests they're not in compliance with the rule. And Peter Biello says otherwise they would have had something to show you. Exactly. So before we look at this Exhibit B, this is the reason Barred Business is saying this writ of mandamus is this critical. We need this relief. The jail is in crisis. These unindicted people are languishing in custody because the DA's office is failing to comply with the most basic requirement. Not only are people forced to sleep on the floor and deal with overcrowding, but officials are sending some to other facilities outside of Atlanta, placing them hours away from their attorneys and their families. Now, this is important for mental health and support, but when you're very far away from your attorney, sometimes your attorney comes and meets with you in person at a facility. Those conversations are protected. But if you live further away, it's more difficult to have that type of support and conversation. Does that sound like a civil rights violation, something that could interfere with your right to a fair trial and a fair defense? I think you could argue that it may. They note here that over the last 2 years, at least 24 people have died in Fulton County Sheriff's custody. And those who are alive are dealing with medical maltreatment, filthy living quarters, and rampant violence. And then they give us the same stats we already looked at. So of the 3,000 and change that are currently detained, that are currently incarcerated, 1,114 individuals, or 37% of the population, are being held without indictment. And they cite the same ACLU report. And they go over the 207 of them have been held for over 6 months without indictment. 503 are held for more than 90 days, way beyond that 45-day window. And I want to go down to Exhibit B, because this is what Julian Clark and Peter Biello were talking about. They sent public records requests in. This is the response that they got. Open records request. We do not have responsive documents. That is the entirety of the response. That's it. They also attached the records request that they made. This is exactly what we're requesting. You can see that this is being filed by the ACLU of Georgia. So after they get that non-response, we don't have the responsive documents, the council, the ACLU, sends another open records request again. Just making sure, are we really reading this right? So they send the same request after the response to the first one. And then in Exhibit E here, we get a response to that second request that says, hey, we're in receipt of this. However, we do not have the responsive documents. But they're required to keep these responses. They're required to file. They absolutely should have this response because code says, the official code of Georgia says, the district attorney shall notify the Chief Justice in writing. In writing. There should be records. If any of this was ever done, this 45-day, 2-business-day window, if this was ever followed, this requirement was ever followed, it would be in writing. So this writ of mandamus, they're saying, look, we need you to enforce the respondent's duty to report this stuff. They're required to report it and they're not, and we need you to enforce that. The judge needs to have notice of how many people are stuck unindicted. So that way you can take action to remedy that problem. So we, Barred Business, request that this court issue a writ of mandamus compelling respondents to comply with her public duty and notify the chief judge in writing of the names of any and all unindicted accused persons who have been in Fulton County custody under criminal felony charges for 45 days or more. They go on to outline the facts that are in their favor for making this request. Hey, we sent public records requests. This is the response they give us. And they also note here that respondent has announced that her office will not indict individuals unless, in her subjective assessment, that's discretion. Subjective means discretion. They are trial ready. This practice causes significant delays and undermines the ability of accused persons to invoke speedy trial rights. But this isn't a decision. At this discretion, there's code. So they're saying here, petitioner's saying here, Barred Business is saying, Fani says herself, hey, we're not going to indict people unless we think we're trial ready. But they don't have that discretion because statute requires, you make this indictment within 45 days, and if you don't, you have to notify a judge in writing. And thus, respondent's refusal to comply with this is preventing chief judge from fulfilling his supervisory role and preventing unjustified pre-indictment delay and subsequently contributes to extended case processing and jail overcrowding. So court, we can't look at the chief judge as being the problem for what we're saying here, because they can't do anything until this notification is provided to them that someone's being held without an indictment. And it's Fani Willis's office's duty to notify the chief judge in writing. If they would do the thing that they're supposed to do, then the chief judge can do what they're supposed to do. But they can't until this other obligation is met. Whereas here, a public official has refused to comply with a mandatory public duty, a writ of mandamus is appropriate. And so they're citing the code. And all we're asking you, court, is enforce. Make Fani Willis's office comply with her duty, her public duty, to notify the chief judge in writing of any of these names of people that have been sitting unindicted for more than 45 days. That's it. We don't have any other specific legal remedy. We just want you to enforce the basic thing, the basic public duty. So they asked the court, we want you to, direct Fani Willis to appear before this court within not less than 10 days or more than 30 days and show cause. So Fani Willis needs to show up to you and show cause why this writ of mandamus should not be granted. It's her burden. She's got to come to you, judge, and show cause. Otherwise, you need to grant this writ of mandamus that we're requesting. And they do also request any other further relief that may be just and proper, including attorney's fees for preparing this. And you'll see here that this was written. If we have Julian Clark, that's our ACLU guy. We also have Andres Lopez Delgado, ACLU guy. Also want to talk about these other two exhibits that are attached. One is a motion for a hearing and one is a transcript from the same hearing. This was filed by an attorney for Jasper Walters, who has been in the Fulton County Jail for 434 days without an indictment. They're citing the same code that we've already seen. The district attorney shall notify the chief judge in writing of the name of any unindicted accused who has been in custody under criminal felony charges for 45 days within 2 business days after said 45-day period has run. This motion is from September 18th, 2023. So keep that in mind. They're citing here in this filing, in this motion, that in May of 2023, at a hearing for another case for Mr. Walters, a Fulton County ADA announced in open court this case was, quote, on track to be indicted. So defense says, how do you know that? And the ADA said that 3 other ADAs told her that, but she wouldn't give the defense counsel any of those names when requested. So by the time they're writing this, they still say that Mr. Walters is stuck unindicted, and there's apparently not even an assistant district attorney working on the case. So they tried to ask back in May, and they couldn't get an answer. And now still at the time of filing this in September, they're saying, we still can't identify an ADA that's even working on the case, with a footnote that says, if there is one, it's a secret that is being more closely guarded than the recipe for Coca-Cola. So in August of 2023, defense counsel tries to communicate with a different ADA about a potential bond hearing. So they can't get this bond hearing. In response to this in August, that ADA says that it hadn't even been assigned. It doesn't seem like it's been assigned to anyone in the complaint room. And he said that he was only going to be prepared for a bond hearing. He didn't know anything about the merits or status of the case. On August 4th, defense counsel emails the head of the intake unit, Executive District Attorney Kenneth Hutcherson, to ask for a meeting about this case. There's been no response at the time of this filing, still in September. On August 21st, 2023, defense counsel again emailed Hutcherson, and at this time copied Madam District Attorney Fani Willis. Defense counsel understands how unbelievably busy the other parties are, but again, there's been no response. On August 24th, 2023, defense counsel again emailed those parties and asked if her emails were going through. Again, there has been no response at the time of this filing. Many eyes have been on Fulton County as former President Donald Trump was recently charged, along with 18 other people, in a RICO indictment. 17 of those people were able to contact the Fulton County District Attorney's Office and quickly obtain a consent bond for their clients, so that their clients were able to bond in and out quickly from the jail. Yet Mr. Walters has been sitting in the Fulton County Jail for over a year, and his counsel is unable to find a single ADA who can actually talk to her about the merits of the case. Is it because Mr. Walters is a public defender? Is it because he is not on the Trump RICO case or another high-level case? And they have this footnote here that it's worth noting the defense counsel can get responses from the ADAs in the specialty division, so major cases like crimes against children, etc. The problem seems to be in these trial division cases. And in this complaint being filed on behalf of Mr. Walters, they reference the DA's summer booklet. The summer booklet talks about the way cases are prosecuted and how the DA's office has transformed. Already. There's a results. Quote, the past administration would pursue an indictment with little to no investigation into cases. Through the inception of the case intake division, the flawed process has come to an end. This certainly is admirable, but this cannot mean, or at least should not mean, that defendants just sit in jail while nothing is being done on their cases. So, this whole DA summer booklet's like, yay, we're not doing what the old administration did and simply pursuing an indictment without investigation. But really, on the flip side of that, it seems like the issue is that they're not even pursuing the investigation at all, and they're letting people sit unindicted. So defense counsel believes she's ineffective if she continues to sit back idly as her clients sit in custody day by day, unindicted, and she can't even figure out who to contact for the state. Mr. Walters has patiently waited for a long time on the very charge for which another person was arrested. So this footnote here says that originally, the investigator from the case took out a warrant for another individual after the victim positively identified that individual as the person who committed the assault. Once that individual provided an alibi, that individual was released from custody, and months later, a warrant was taken out for Mr. Walters. To date, there has never been any identification made of Mr. Walters as the perpetrator of this crime, and in fact, the driver of the car would state that Mr. Walters was not the passenger of the car. Here, this filing, this motion, we want this, please. The chief judge has the power to step in. Mr. Walters is asking, begging for you to step in. Mr. Walters is asking for a status hearing so that his case can either proceed forward or not. He maintains his innocence, but this limbo that the state is keeping him in is a violation of his due process and constitutional right, and he's not alone in this. So they start to cite these stats. 3,600 people are being held pre-trial at the jail, the same jail that Mr. Walters is at, and only 36% have had their cases indicted. This footnote here cites an article from The Messenger, who is now closed down. But if you followed any Jonathan Majors coverage or criticisms of Alvin Bragg's district attorney's office over in Manhattan, The Messenger unveiled a lot of interesting stuff, in particular in relation to the Jonathan Majors case, how the district attorney was cutting deals with his accuser, Grace Jabari, before, even though Jonathan Majors made a police report and two different detectives found probable cause to arrest Grace Jabari. Before it even came across the district attorney's desk, the district attorney made a statement. We heard about that statement through Ross Kramer. Grace Jabari's pro bono attorney appointed by the nonprofit Sanctuary for Families of New York, that the Manhattan District Attorney's Office planned not to prosecute. They didn't even come up with a basis. It was just pure preference. And ADA Aaron Tierney made a statement saying, hey, we struck this deal with her because she's going to cooperate and testify against Jonathan Majors. And Ross Kramer says overall there's going to be zero legal repercussions for Grace Jabari whatsoever, even though she testifies at trial that she started the physical altercation. The driver, interesting here, right? This parallel here. The driver of the car where this alleged assault took place says that she, Grace Jabari, was doing everything. He, Jonathan Majors, was doing nothing. And we have Grace Jabari's own words saying, hey, I started the physical attack because I wanted to take his phone from him. I even struck him 10 minutes later after this incident. When we got back into the car again, I struck him. And she makes a motion with the right hand, which is the same hand that ends up having this injury that the Manhattan District Attorney's Office charged Jonathan Majors for. In that case, we saw motions filed for speedy trial violations and changing charges, changing language of the complaint. We also saw a very great investigation done by the prosecutor. They waited 4 months to interview the treating physician from Bellevue Hospital, William K. Shang. They waited 4 months. And there was a lot of Brady and Giglio violations being alleged by the defense counsel in that state, in that case as well. And even though it was a misdemeanor case, it took from March. Today's the 1 year on that, by the way, since the arrest happened. His trial didn't start until December. He was never offered a plea. These are big issues that impact people. But I say all that to go to this footnote here is that the Messenger is talking about this, but now the Messenger is shut down. So unfortunately, the Messenger was covering things like this. They're one of the few that were coming forward with important information, some detailed coverage. And they're one of the ones that gets the axe. So that sucks. But anyway, this complaint being this, this motion that Susan Tevis is bringing forward on behalf of their client, Mr. Walters, they bring up that the DA's summer booklet says that 100% of all unindicted cases, a backlog from the previous administration, have been cleared. The booklet says 80% of all cases received by the office in 2021 have been processed by charging. 60% of all cases received in 2022 have been indicted or dismissed. And the case intake division is on track to clear all 2021 cases this fall and all 2022 case this winter. So we're obviously looking at a motion that was filed in September of 2023, but we're seeing a complaint being brought forward in March of 2024 by Barred Business with ACLU attorneys helping to draft and write the complaint. But here, Suzanne Tevis asks, hey, Mr. Walters moves this court to set a date for a hearing so the district attorney's office can provide the list of unindicted inmates as required, where the DA's office can address the status as to Mr. Walters' case and explain what actually has been done in this last year that he's been in custody, and that the court can set status hearings and scheduling orders for other jail unindicted cases over a certain time period and provide any other relief the court deems necessary. So this is a motion for my client, but hey, this should extend to others. So others, all these other unindicted cases do not end up lost in the system, just like my client, Mr. Walters. We also have the transcript of the hearing here. And of note, I noticed that this is before the Honorable Earl Glanville, who you may recognize if you've been following the YSL trial. This is Judge Glanville. This transcript is several pages long, but I linked to this whole filing, and this is an exhibit in the filing. You can read it if you want. You can read this transcript. And here Glanville is saying, I'm familiar with, because Ms. Tevis, the attorney representing Mr. Walters, has asked, come on, can we just get a schedule? Can you give us some updates? Can you at least let us know what's going on? Because I don't even know who the ADA that I'm supposed to contact is. It's been a year. So court, Judge Glanville responds saying, hey, I'm familiar with, I know that our district attorney and her staff and team are culling through a lot of the unindicted matters. I participate in, I would say, a monthly update on the progress that all of us as justice partners are making. And it's a lot. Having said that, of course, I also am familiar or aware that Mr. Kenner and people from your team and people from Ms. Willis's team meet weekly to kind of go through the cases that you believe can be resolved, are unindicted, or whatever. They come in different categories. And I think to that extent as well, we're going to try Saturday court at the end of the month to see if we can move some more cases. I know that my colleague, Judge McBurney, has volunteered to sit and participate in that. So they're bringing in another judge. So, this is another vehicle. I don't have any issue with it. So even though Mr. Jenkins, the attorney present for this hearing for the state, said he's going to go ahead and deal with what's going on with Mr. Walters. He's going to fast track this and get some answer for you on Friday. That's covered in the rest of this transcript. But for the other folks, my suggestion is that when I set this date for you all to come back, that you use that date as kind of a benchmark to say, okay, here's the people that we think we can kind of address, and then, tell me what your plan is. That might be just a way to, and I'll facilitate anything I possibly can. I don't have an issue with it. But I'm going to leave you all to do the heavy lifting, because that's where it lies. I can provide you a forum and some accountability, but understanding there are a lot of other factors that I don't control because I'm the referee. But I can go ahead and at least, pursuant to this Rule 26.3, kind of just inquire. I can inquire. And I think that will, as we say in the military, that is a forcing function, that's fine. I don't have any issue with that. So Mr. Jenkins, that's the state. Is that acceptable to you? It is, Your Honor. And then he says, and to that extent, Ms. Willis has reached out as well and has screened several hundred people that are bond eligible, or she's going to grant, or agree to have bond, I should say, too. So I know that some things are happening, Mr. Tevis, and I don't have any issue with you bringing this to my attention. Blah, 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 blah. So they set this for the 3rd of October, and I'm going through this transcript because I want to reiterate that we now have barred business with help from ACLU counsel, filing this on March 14th, 2024. So Judge Glanville says, hey, I'm going to work to try to expedite this. Fani Willis says she's combing through these hundreds of things and has a plan for all these unindicted persons. But fast forward 5 months, and here we are with this complaint coming forward that all these unindicted people are still sitting there. And I also think it's kind of comical. A lot of the commentary about the YSL RICO trial is they're predicting it's going to go into 2027. And Judge Glanville is running significantly, shockingly short calendar days. Some days are being canceled entirely. Other days are starting at like 3:30 in the afternoon. Then you have this guy saying, hey, we're going to allocate some time to get this calendar moving and help. I'm only the referee, but I can help where I can help. And I'm not sure that's the best equipped solution there. But anyway, those two things, that motion and then the hearing for this motion brought forward by Suzanne Tevis on behalf of Mr. Walters, had some interesting stuff in them. They're included in the full barred business complaint here, which I'll link to in the description if you want to look at them yourself. Interesting stuff, how everything overlaps, isn't it? I wasn't going to include this motion and the hearing transcripts at first, but I went back and recorded this bit to chop it in where we were talking. So let me weave back to what I was saying and we can get on out of here. And my whole point was, I see this video from AV. I go and look and I see, hey, this is still Fani for DA. This is her campaign platform, this diversion program. Then we have this ACLU report that says, hey, there's been some movements from other parts and pieces, right? We've seen some great improvement, the most significant improvement from what the solicitor is in charge of. So shout out to Solicitor General Keith Gamage. The ACLU says we've seen significant improvement there. But we haven't really seen significant improvement here. We went from 3.4% to 3.2%. And it's because someone's not following their duty to notify someone in writing. Because there's no records. They're not doing it. They have no records. They said, we have nothing relevant to your public opens request. There are no responses that we can send to you. Which suggests that they never sent written notification to the chief judge for any of these people that have been sitting for more than 45 days. It'd be different if it was a small sample size, but it's over 100 people per year. So that's really what I've got, you guys. I think this is such an interesting issue. It kind of, there's an overlap between the PR, the political campaigns, versus civil rights, research, reports. We have the ACLU really coming into play here. I didn't realize that until I opened the bottom. I knew the ACLU, their research and their counsel participated in what's being used to file the suit. But I didn't know that the ACLU attorneys actually penned that complaint. So we can say that the ACLU, two attorneys with the ACLU, penned this complaint on behalf of their client, Barred Business Foundation. There's been a lot of discourse back and forth at saying, hey, they're looking, the Trump's co-defendants, the attorneys, they're looking for anything to fire shots across the courtroom floor over at Fani Willis to try to discredit her. This is an issue that exists outside of anything relating to the Trump RICO. In fact, I'd actually argue that one could say Fani Willis's office is so focused and allocating so many resources to prosecuting these select few RICO cases that they're not really addressing this backlog that was platformed on. There's people that are sitting unindicted because they're not getting the same attention that the Trump RICO or the YSL RICO, they're not getting the same attention. Even though they're required to just as simply send, hey, it's been 45 days and we haven't indicted this person yet. Because we personally here at the Fani Willis District Attorney's Office, we've decided to use our own discretion and say we don't want to indict individuals unless we feel they're trial ready. That's a problem. And that while I will reiterate that this is a problem that's probably not only a problem in Fulton County, Julian noted that he believes that there's problems with the same type of, someone's being held without indictment for too long, that's something that could be happening in other parts of the state as well. But we do know that the national average is 30 days compared to 291 days as an average here in Fulton County. So when you put it in perspective, when you look at the big picture, Fulton County is certainly an outlier. Why are they an outlier? Especially when they launched diversion programs that are the exact point in the timeline, pre-indictment, post-arrest. Those diversion programs that Fani Willis is campaigning on and platforming on deal with a part of the timeline that would significantly address and impact this issue. So why isn't that happening? Again, I will link to all of the links that you've seen on the screen here throughout the video in the description here. I hope this is a great conversation starter, whether, again, you care about how tax dollars are being allocated or you care about impact to individuals that are dealing with directly the effects of being incarcerated without an indictment, or, the friends, family, the council, any individuals that could indirectly be impacted by that. I'm interested in your thoughts and your response either way, wherever your come from is, whoever you are, the floor is yours. So leave your comments below or in the chat if you're watching this on the premiere. But the scope of this impacts a ton of people. This could impact anyone that ever comes across the incarceration system in Fulton County. So with that, I'll turn the floor over to you guys. Leave your comments and thoughts. It's an open floor. You don't have to agree with me, although I do hope you agree that it sucks for someone to sit in jail for so long without an indictment. That kind of sucks, right? So hopefully, if you disagree with me there, be loud in the comments because I want to see it. But, all those other nuanced things that you might think about, let me know because it's always something for us to consider. Let me know your thoughts. Again, links in the description for, these documents, AV stream, everything like that. You guys take care until the next time we have a video, but I'm looking forward to your thoughts and discussion.